a guide to how exclusion of liability clauses can be included in your agreement with consumers. Oh, Zidane, come in. Welcome.
Hi, Melis. How are you?
Hi, I'm excellent. How are you?
Good. It's really nice to see you again.
It's a pleasure. So, what brings you in today?
So, as you know, I'm in the process of starting a new business venture. It's going to be an online-based platform, and therefore I just need some help in ensuring that my business will be protected from any lawsuits. I also want to ensure that, because I'm a startup business owner, that no consumers try and take advantage of me.
Yes.
How would you be able to help?
Fair enough, Zidane. That makes perfect sense. Now, I appreciate you coming in today, and it is my pleasure to help you.
Thank you.
Now, today we're going to touch upon a few topics during our discussion today. First of all, before you publish your website, you need to ensure that you include a terms and conditions agreement. This can be implemented through either using a clickwrap or a browsewrap format. To protect yourself from liability, we will include an exclusion clause, or sometimes known as limitation of liability clause. I will also explain to you slightly about how loss works, and in particular consequential loss, and how you can limit your liability for it.
Wait. Sorry to interrupt you, but this is all very confusing. Can we please start from the beginning?
Of course, no problem. Now, to start from the beginning, terms and conditions is essentially a virtual contract between the users of the website and the business. Website terms and conditions are a detailed legal notice that states the terms that visitors, users, and customers of your website must agree in order to browse your website or use your products and services. The terms and conditions of your website become a legally enforceable document upon acceptance of the user. Terms and conditions ensures you are covered from financial loss that may arise from any potential dispute, and they become a legally enforceable document through the use of clickwraps and browsewraps, which will be further explained. Now, Zidane, did you know that 94% of Australians don't actually read the terms and conditions?
Wow, really?
Yeah.
Wait, so does that mean I don't need to include a terms and conditions agreement on my website?
Not necessarily. Now, terms and conditions are not legally required. However, it is strongly recommended to include them. Terms and conditions ensures you are covered from customers claiming to have suffered loss from your content or using your products or services. It also protects you from visitors of your website copying your content, claiming damages from viruses, etc. It is intended to cover visitors, users, purchasers of your website, and subscribers to your services.
Sounds good, Melis. You have me convinced. So what exactly should I include in my terms and conditions?
Glad you asked. The most common clauses are as follows, but not limited to intellectual property clauses, trading clauses, and privacy law clauses. In addition to registering your trademark, your terms and conditions can protect your website's intellectual property from unauthorized use. A copyright and trademark clause informs your users that you are the owner of all the content contained on your website. This type of clause can specify that users of your website are not allowed to reproduce your content or trademark without your written consent. Secondly, trade rules. If you are selling goods or services online, you'll often need a merchant account to accept credit card transactions. Banks regularly request a copy of your website terms and conditions before they issue you with a merchant account. And if you are selling goods or services online, your terms and conditions should stipulate your refund, repair, or replacement policy and details on your warranties and your guarantees.
Interesting.
A privacy policy is a statement or a legal document that states how a company or website collects, handles, and processes data of its customers and visitors. It explicitly describes whether that information is kept confidential or is shared with or sold to third parties. You should have a privacy policy even if you don't collect personal information, because the general public and authorities both expect to see one. Without a privacy policy, you may end up having to explain your privacy practices to legal authorities to prove that you aren't violating privacy laws. You may also lose trust with the public for not being clear about what your privacy practices are. Now, moving on to clickwrap and browsewraps. In recent years, we have seen an inflation in online businesses. As most businesses prefer to conduct transactions over the internet, it is important for business owners to understand and know the legalities of how online contracts are enforced in Australia. Clickwrap agreements require the users of the website to acknowledge and/or accept its terms or conditions by clicking an acceptance checkbox before proceeding. As presented in the images, a clickwrap agreement is a form of electronic signature where the act of signing via an electronic signature is replaced with the act of clicking to check a box or a button that includes acceptance language, such as "I agree" or "I accept." Clickwrap agreements are the best way for businesses to limit their risk without impacting conversion or customer experience. Companies add clickwrap agreements to sign-up pages, checkout flows, and login pages. Browsewraps, on the other hand, are included in a hyperlink on the website's homepage, usually somewhere within the footer. By merely accessing and browsing a site, the browsewrap method assumes that the user agrees to the site's policies, even if they haven't actually read the fine print themselves. The image on the top is an example of how a browsewrap should not look, as it is rarely visible and not easy to locate. If links to policies are not easily accessible, users can argue that they had no knowledge of the site's terms and conditions in the case of a legal dispute. The image on the bottom is a better example of how a browsewrap should instead be presented. It is important to catch the user's attention with a banner that follows them as they scroll down the page. This method is more likely to be upheld in courts. Clickwraps are the preferred method of enforcing online contracts. The principles of contract law have supported the enforceability of clickwrap agreements in the United States since the 1990s. Since 1999 and 2000, respectively, additional statutory support for the enforceability of clickwrap agreements has been provided by the Uniform Electronic Transactions Act and the Electronic Signatures in Global and National Commerce Act. Clickwrap agreements have also been supported under international law. Clickwraps, however, must be clear, concise, and capable for acceptance. A 10th Circuit decision from 2012, Hancock and T&T, illustrates this principle. In the case of Hancock, AT&T consumers argued that clickwrap agreements did not give them notice and meaningful opportunity to assent to the forum selection and arbitration clauses in the terms of service. AT&T technicians presented customers with a printed copy of the terms and gave customers an opportunity to review the terms, to which customers agreed by clicking on the "I acknowledge" button or "I accept" button. Customers also clicked the "I agree" button to manifest assent to the internet terms, which customers had an opportunity to review in a scrolling text box. The court found that clickwrap agreements are enforceable. Clickwrap agreements have been enforced even when the customer did not read the agreement. Now, many courts have refused to enforce browsewrap agreements because of a lack of user notice and assent. The notion that users assent to browsewrap terms simply by using the website is problematic, because oftentimes users will use the website without ever knowing that a browsewrap agreement exists. For example, the court in the case of Spect and Netscape declined to hold Netscape's browsewrap agreement enforceable. This is because the hyperlink's placement at the bottom of the screen failed to put users on notice of Netscape's terms. However, we found that when a user has actual notice of the agreement, courts tend to uphold browsewrap agreements. But actual notice can be difficult to obtain and hard to prove. Actual notice often requires more than just a simple implementation of a browsewrap agreement.
Thank you, Melis. We will now move on to exclusion clauses. Exclusion clauses, or as they are sometimes known as limitation of liability clauses, are clauses that are inserted into agreements to reduce legal responsibility in the event that something goes wrong. Exclusion clauses can be inserted into a variety of contracts. However, today we are focusing upon its inclusion in a terms and conditions agreement. Carter and Harland identify three different types of exclusion clauses. The first is to exclude the rights that a party otherwise enjoys by the terms of the contract or at law. The second would be to restrict the rights of one party without necessarily excluding the liability of the other party. The third is to qualify rights by subjecting them to specified procedures. Each business will have a different exclusion clause to the next business, as the exclusion clause is catered to their own needs. Hence, the type of exclusion clause included in your terms and conditions agreement will go on to reflect the bargaining position of the parties. I have devised a 4-step process on how to approach exclusion clauses. The first step would be to ensure that your T&Cs agreement is easy to find. This is done by implementing a clickwrap or a browsewrap, whichever is more suited to your business, as Melis touched upon earlier. This is important, as if you don't bring the actual clauses specifically to your customer's attention, a court may decide that the customer did not have sufficient opportunity to see the clause and agree to it. Secondly, it is important to ensure that your clause is easy to read. You want to ensure that the average consumer will understand exactly what you're trying to say. Therefore, it's important to use basic English rather than terminology that might be seen to be too legalistic. Thirdly, when drafting your clause, ensure that all the different types of liability are excluded. Liability can be excluded by, for example, putting an upper limit on the amount that you can be sued for, setting a minimum threshold that must be met before you can be sued, or setting a time frame to limit when someone can make a claim. Finally, be aware of types of liability that are not allowed to be excluded in your area, either by legislation or case law. Examples of exclusions from limitations of liability include, but are not limited to, losses and damages resulting from breaches of confidentiality, refusal of services, willful misconduct, bodily injury, death, damage to physical property, violations of applicable laws, and gross negligence. I will now give you guys a quick rundown on how the exclusion clause should be structured and what's required in your agreement. The first provision under this clause should explain that all information found in your website, while believed to be accurate, may in fact be incorrect, out of date, or inaccurate to some degree. Explain that the information is provided in good faith on an as-is basis, meaning it should only be taken at face value and not to be relied upon to any extent beyond which the law requires. This is because certain information by law is required to be accurate. As such, draft into the provision a sentence that excuses the company, its directors, officers, and employees of any liability for any representations or possible warranties between the company and the user. Of course, your business lawyer cannot simply excuse your company for any responsibility and must draft according to the Australian Consumer Law or ACL. In your second provision, acknowledge the ACL and accept that certain rights and remedies relating to the provision of goods and services will be afforded to customers of your business. This provision is essentially an acknowledgement of the rights of consumers who purchase your business products and services. In the third provision, have your business lawyer draft an exclusion clause that limits the applicability of any implied conditions or warranties, apart from the customer rights as defined above. Of course, limit this exclusion to the extent permitted by law. It should apply to the following: expressly disclaim any implied or express guarantees, warranties, representations, or conditions of any kind which are not mentioned in the sale terms. Explain that no promise will be made to the user of the site that accessibility and use of the site will be error-free. Your business lawyer might want to also limit your liability insofar as the server transmitting or storing viruses to users of the site are concerned. If the site or its products are unavailable, it will not be the business responsibility. Finally, your business lawyer should also draft a provision so that the business is not responsible for any loss, damage, or cost caused by the use of the site to the users of the site. This should be broad enough to encompass every possible variation of liability. There are 5 types of losses that can be excluded: special, direct and indirect, pure economic, and consequential. Melis will now go on to introduce a specific area of liability that is quite challenging and, if not handled correctly, could in turn lead to your exclusion clause becoming null and void. This is consequential loss.
Consequential loss has been a vexatious topic in Australia for decades, until the decision delivered by the Court of Appeal in Victoria, the case of Peerless. As per company contracts, it is common for consumers and suppliers to rely on company policy to not accept, under any circumstances, liability for consequential loss. Before the decision in Peerless, Australian courts generally followed a line of English authority that the term consequential loss and exclusion clauses represented losses which fell within the second limb of the rule in the case of Hadley and Baxendale. This is loss that does not arise accordingly to the natural usual course of things, but which the parties, at the time they made the contract, contemplated as being the probable result of a breach of contract. In other words, the second limb rule for consequential loss meant that the parties could have reasonably foreseen or expected to see a form of loss arising from a breach. For almost 150 years, this interpretation of consequential loss was upheld until the case of Peerless decided it was incorrect. The judges in Peerless held that exclusion clauses, such as a consequential loss clause in a commercial context, should be given its ordinary and natural meaning, as would be conceded by ordinary, reasonable business persons. The court focused on the true distinction between what was described as normal loss and consequential loss. This distinction was expressed as follows. Normal loss, which is loss that every plaintiff in a like situation will suffer, and consequential losses, which are anything beyond the normal measure, such as profits lost, or expenses incurred through breach. It is clear that the decision in Peerless changed the law in Australia. Previously, an exclusion of consequential loss may not have been sufficient to exclude loss of profits, loss of production, and other categories of loss, unless those losses fell within the second limb of Hadley and Baxendale. As a consequence of this decision, it is apparent that clauses that exclude consequential loss will be interpreted by the courts as excluding all losses which are not normal losses. However, what is meant by the concept of normal loss? What is meant by every plaintiff in a like situation? To determine such questions, the following may be relevant: the particular characteristics of the plaintiff, the background and circumstances of the breach, and the background and circumstances giving rise to the loss. Consequential loss is essentially determined by the specific factors that are relevant to the situation. Over the past century, the High Courts have had different interpretations of what consequential loss is and how it should be applied in terms of a contract. The three main cases as presented on the slides have been the most influential in shedding light on consequential loss. In the case of Alstom and Yokogawa, a very broad approach has been taken using a literal interpretation of the word consequential, so that consequential loss means any loss that was consequent or following, immediate or eventual, following from a breach of contract. In the more recent case of Pacific Hydro in 2013, the position is different again. Here, the court rejected the Victoria position of Peerless, beyond the normal measure, and also excluded strict reliance on the second limb test. Instead, consequential loss exclusion clauses should be construed on a case-by-case basis according to their natural and ordinary meaning as determined in the context of the relevant contract when read as a whole. In summary, there is still an obligation to give clauses their natural meaning, but there is no consensus on what is meaning for consequential loss. The solution is comparatively simple though. Whenever you want to deal with consequential losses, define that term in the contract so the meaning is clear.
Therefore, As we now understand from what Melis has explained, simply excluding liability for all consequential loss may result in your clause being unenforceable. Here are a few steps to take when including consequential loss in your terms and conditions agreement. Decide what specific types of indirect or consequential loss you want to exclude and then list them in the definition. If included, then the meaning will be clear. If you do not include a specific loss, then the meaning will be open to dispute later. For example, simply stating that consequential loss means any and all indirect or consequential losses is of next to no real assistance. Consider if there are any specific exclusions from the general classes of consequential loss that you list. The most common is delay liquidated damages. Liquidated damages are a means of compensation for the breach of a contract. When liquidated damages are calculated, they will take into account a variety of factors, some of which could fall within your definition of consequential loss, such as business interruption. To avoid any ambiguity, simply make it clear that the exclusion of consequential loss does not apply to liquidated damages. Liquidated damages will then be a separate head of loss that is a genuine pre-estimate of losses associated with delay that does not fall within the consequential loss exclusion. Now we're going to consider insurance implications. There is no sense in requiring the other party to have a policy that names you and has a coverage of, say, $20 million if you then exclude their liability for a large part of what the policy covers. As most consequential loss clauses are mutual, excluding liability of both parties, you should always check with your own insurance broker before doing so to ensure that this does not diminish coverage under your own policies. Rather than having an argument with an insurer over whether it is only required to indemnify parties for their contractual liability, which excludes consequential loss, consider whether it is necessary or appropriate to carve out insurance coverage from the consequential loss decision. In that way, the other party will reduce its direct personal liability, but you will both have the protection of the insurance policy. Lastly, look into how the consequential loss exclusion impacts or interacts with other clauses of the contract, in particular indemnities or warranties. Be aware that a specific exclusion of consequential loss may reduce a more general right of indemnity or ability to enforce a warranty. For example, it is common to carve out from the consequential loss exclusion the indemnities relating to personal injury and death, so that these remain in force irrespective of whether elements of the indemnity would usually be considered as consequential loss. It is important to note, however, that there are a few situations where consequential loss would not apply. This includes, but it is not limited to, loss arising from death or injury, criminal acts or fraud, wrongful or intentional act or omission or willful misconduct, liability for liquidated damages, infringement of any intellectual property right, a breach of the confidentiality provisions of the contract, liability under any of the express indemnities contained in the contract, or liability which by law the parties cannot contract out of.
Now, to wrap things up, terms and conditions are not legally necessary, but to the best of our knowledge, it is strongly recommended to include on your website as a startup business. To enforce the terms and conditions, clickwrap and browsewrap should be used. It is up to your own discretion as to which method you would prefer, as it depends on your business model.
The inclusion of an exclusion clause is vital in ensuring you are protected from liability. As we have seen, consequential loss has been interpreted differently by the High Court, and therefore it is important to be specific in what you want to exclude. We thank you for listening to our presentation. We hope it has been informative, and we wish you all the best on all your future endeavors. Thank you.
Thank you.